so much. So I also have the privilege of chairing two panels. So my panel this morning was fantastic because we had perspectives from China around clinical legal education, which was really interesting because the speaker Frey was comparing that to the approach taken in Holland. So it's really interesting to see those different comparators and to also talk about the development of the clinical legal education in China, which is something that even though I engage in clinical legal education, I wasn't aware of some of the challenges they were facing in regard to that. So that was really interesting. And then Michael talked to us about street law, and I think lots of people are really interested in street law, but what was really great about that presentation is that he was looking at it from a business, from an insolvency perspective, and I think it shows the diversity.
Thank you very much for your presentation. My special greetings for Worcester University, Open University, Nottingham Trent. My conference name is Legal Training, Human Rights and Digital Procedural Skills, Notes from Latin America, by server Arlex Martinez Artunduaga. This conference aims to analyze the new challenges facing legal education, training students in human rights and digital procedural skills. The order of this presentation is digital human rights and procedural guarantees, procedural mechanisms and human rights, from traditional understanding to contemporary virtual challenge, impact of AI and virtual environments on legal education, and finally conclusions, pedagogical proposal for incorporating digital procedural skills into human rights training. First, digital human rights and procedural guarantees. Recently, the rise of artificial intelligence and its use in both educational and legal settings has led to the removal of apparent stability that had been achieved in virtual media after COVID pandemic. Once again, this is a push towards digital mechanisms and skills such that the traditional exercise of jurisdiction and the teaching of law, analog or traditional mode, seems to have been definitively transcended. Of the past, we could always say, like replicant Batty in Blade Runner, all those moments will be lost in time like tears in rain. Yuval Chani has referred to three generations of such guarantees: digital rights that arise as an adaptation of existing rights applied to virtual environments, new digital rights create or guarantee access to the internet and not to be subject to automated decisions, and the generation of new subjects of rights and obligations such as virtual persons and platforms. As an example, we can cite the rights recognized in the United Nations Resolution of September 26, 2019. It presents the right to privacy in the digital age. It warns against the effects of automated decision-making, machine learning, and biometrics. Similarly, as an important point, it urges states to provide qualified education that is accessible to all, including digital literacy and technical skills that enable citizens to provide their privacy. Some of these guarantees were reiterated in United Nations Resolution December 16, 2020. These instruments served as the basis for UNESCO's ethical recommendation on artificial intelligence. The principles refer to proportionality and harmlessness, safety and security, fairness and non-discrimination, sustainability, privacy, oversight and human decisions, transparency and explainability, responsibility and accountability, awareness and education, governance and adaptive collaboration. This is certainly a very interesting spectrum of protection. However, there is a need for a greater depth in procedural guarantees that can be adapted to a jurisdictional function that is now digital and face the challenge of the appropriate and ethical use of artificial intelligence. For the time being, international instruments seem to be limited to digital governance as a matter of public policy rather than a matter of procedural safeguards. Although some derivation in this regard could be stabilized on the basis of access of justice. Possibly, as seems to be inferred from of some of these things cited and from Muller's work, the greatest concern so far stems from the possibility that judicial decisions may be taken by an automated entity rather than by a human judge. Second, procedural mechanisms and human rights, from traditional understanding to contemporary virtual challenge. Traditional teaching on procedural mechanisms highlights the transition from isolated reflection on civil and criminal procedures to the consideration the so-called general theory of procedure. This is defined by Niceto Alcalá Zamora as the exposition of concepts, institutions, and principles common to the different branches of prosecution. In the Latin American tradition, the historical framework was inspired by authors such as Chiovenda, Carneluti, Goldsmith, Bullough, Bach, and Calamandrei. The core of the general theory of procedure comprised the triad of action, jurisdiction, and process. The attempts at conceptual and doctrinal dispersion faced by the great theories of half a century ago could arise again in this context of virtuality and human rights in relation to the ethical use of AI. This is a discussion that already took place when Haberle proposed that constitutional procedural law should generally autonomous base for his understanding, considered it as concrete constitutional law. In contrast, Steen thesis prevailed, which considers that general procedural theory continues to be a framework within which constitutional proceedings are situated beyond the particularities that arise from their specific jurisdictional functions. The teaching procedural law fights with the challenge posed by virtuality and AI in the context of human rights as choosing to preserve the strong core of general procedural theory. Authors such as Calvino understands that process acts as a guarantee of guarantees. Sanchez Bayon, Campos, and Fuentes show how, in the European and Inter-American human rights systems, concerns about mechanisms for petitioning, reporting, and supporting victims, general rights uses relate to the right to take legal action. In the field of virtual justice, particular difficulties have been encountered than the compromised human rights. One of these is the guarantee of a natural judge, since without a doubt, decisions should not be automated, but rather require human control when resolving case. Thus, Botero et al. Point out the impossibility of delegating tasks such as regulatory interpretation or judicial easements to AI. The generation of erroneous data, of which hallucinations are now prominent, as well as prejudice, algorithmic bias, transparency, and explainability, are other questionable points in the use of AI in justice. On the contrary, its contribution is useful for categorizing documents, assigning case, and notifying resolutions, as is the case in Argentina. For example, it could be used to classify documents, as in the case in China, a country where AI is also used to predict decisions based on historical records and resolve minor disputes. Third, impact of AI and virtual environments on legal education. A general review of legal education in virtual environment allows us to understand how legal formalism derives from the continental tradition in which deductive logic, memory, and lectures predominate has been overcome. Now, the case study method based on precedent has been incorporated with the constitutionalization of law in Latin America and the reception of the Anglo-Saxon tradition. Others have turned to realistic pedagogy, emphasizing the sociological factors that influence judicial decisions by later. As Prieto pointed out, after weighing up these methods, the education system has considered important to preserve those aspects of legal training that only humans can perform, such as interpretation, critical judgment, and ethical and moral decision making. The use of AI in law school has been beneficial in four main areas: content accessibility, learning personalization, analytical skills development, and teaching management efficiency. Some authors show how the use of the CATO systems to analyze precedents in the review by bench Capon and Praken led to improvements in the identification of analogies and distinctions, while Gardner's results reflect the construction of structured arguments in the case studies by undergraduates. On the negative side, Pasquale and Caswell refer on premature cognitive delegation, whereby students place too much trust in AI with bothering to develop their own critical thinking skills. This phenomenon could lead to the technological dependence as pointed out by Signeruti and Bell. Likewise, the incorporation of components of technologies, ethics, and algorithmic responsibilities is required. Ultimately, the aim is to move beyond traditional deductive or rote learning, embrace case studies in virtual environment, and formulate participatory, inclusive, and adaptive policies taking into account the cultural and structural specificities of Latin America. Conclusions: Pedagogical proposal for incorporating digital procedural skills into human rights training. The conclusions of this conference presented in the form of proposal revisit the trade of general procedural theory, action, jurisdiction, and process, change in pedagogical training in the face of the challenge of virtuality must be recognized in one of these frameworks of understanding. In this way, emphasis will be placed on the fact that the incorporation of new technologies in legal education and judicial proceedings is not an end in sight, but is aimed at preserving the rights or guarantee of the parties, especially digital human rights. First, the right of action is very well represented when legal education incorporates simulation exercises with adequate technological support for activities such as filing petitions and compliance through virtual means, drafting briefs, and above all, critical reviewing their production when virtual and AI support is used on this preparation. Students must be able to recognize the doctrinal and jurisprudential foundation they will use in their professional practice and detect the hallucination and delusions of AI, mainly through their own professional and legal judgments. That is why they want to be lawyers. Second, jurisdiction. Subjects related to commercial, administrative, insurance, tax, and copyright law, among others, benefit from incorporating knowledge and practice of relatively automated justice in e-commerce platforms, financial service, police and traffic claims, social media, images use, and the like. These are issues where, in addition, territorial and transnational jurisdiction are often quite intertwined. The main emphasis is on guaranteeing the right to a natural judge and on understanding mechanisms that allow the transparency and reliability of automated support to be questioned. Where necessary, control and recourse to strictly human decision-making must be demanded in all cases. This is an ethical and epistemic challenge that compromises jurisdictional guarantees in the context of digital human rights. Thirdly, the process. Simulation exercise on virtual hearings are practices that today can include remote interchanges in court and tribunals. The acquisition of skills to present and formulate arguments with the support of AI and human control is particularly noteworthy. The collection, processing, and presentation of evidence, as well as the assessment of evidence and the formulation of inference and reasoning that persuade judges, can greatly benefit from the incorporation of digital skills. In any case, these practices are a good opportunity to combat bias, inequality, and the denial of justice due to the inability of parties in a position of weakness to mount a sophisticated defense of their interests. The requirement for judicial reasoning beyond the difference that exists in this regard between the continental and Anglo-Saxon systems can benefit from the guarantee of explainability and consistency formulated from digital human rights. Finally, these proposals are oriented from a legal training perspective toward an exercise of AI and virtually that contributes to overcoming rather than deepening the traditional hidden exclusions of the justice system. As Mark Galanter Wolf said, repeat players tend to predominate over those who only occasionally approach the courts or one shooter. The question of the humanization of digital justice will be applied right now to our face-to-face forms and practice with equal or greater emphasis. I have always wanted to take the liberty of conclude a dissertation with an extract from a speech by our genius Charles Chaplin in his film The Great Dictator, a phrase that sums up the purpose of this conversation very well. Don't give yourself to these unnatural men with machine means and machine heads. You're not machines, you're not cattle, you're men. You have the love of humanity in your hearts. Thank you very much for your time, for your attention. Thank you very much.